Thank you. Please be seated. So we're back on the record. Sir, you remain under oath, and as I recall, Mr. Gutierrez, you were going to ask him about Martinelli.
Yes, Your Honor. Thank you.
But I want to back up a little bit, please, the court. I want to come back around to a few other things before we get to Mr. Martinelli's report. Sir, when you teach use of force, is there a thing called a threat assessment continuum?
Yes.
Could you explain that to the court, what that is? Objection, Your Honor. It's his training. When he trains.
Well, it is correct. If you're going to ask him all these opinions, but let's...
Judge, this is not an opinion.
Hold on. I'm going to overrule the objection. But you really do need to have the opinions you want to elicit in court touched on in the report, but overruled. So threat continue.
Sir, do you train that?
Yes.
In the last 40 years of you in law enforcement?
Yes.
Okay. Could you explain what that is?
We talk in terms of kind of a color code of assessments. For example, we start with when an officer is at home in his or her or his easy chair watching television, you're kind of, without feeling of threat, nothing's going to happen, there's only the family to worry about. And then it progresses up to yellow, orange, and red. Orange is the assessment of things going on around you for perceived danger, that you are ready, perhaps hand on your firearm, on your taser, ready to use OC, going for your baton, whatever it is, you're at that assessment of what level of force now are you perceiving as the threat. If it's an unarmed physical encounter, is it a deadly encounter with someone with a firearm or an edged weapon? All of that is an assessment of what you are facing, and you reach for the weapon that is trained under those circumstances, and you conduct yourself in a manner to handle that kind of threat given the training you've had as to what you need to do. For example, if it's a physical encounter, you may begin to approach and take control and command of the individual. If it's a deadly encounter, you're assessing that you have to remain in a position of safety for yourself and other officers and engage differently under those circumstances.
And in this particular case, you opine Officer Brelo did some of that assessment, would you agree, regarding his ambush training tactic?
Mistakenly, but made objectively reasonable assessments of what was going on at that time.
And according to your opinion, it's behind the trunk is where you opine those assessments were what, faulty?
Objection. Overruled, although we've heard this 3 or 4 times.
Oh, okay, then I'll move on, Your Honor. Sir, based upon your experience, your training in law enforcement, what, 50 years? I'm sorry, I said 40, but it's been 50. You've been in chases yourself, correct?
It chases, yes. Foot pursuit and vehicle, yes.
And there's a basic psychological component with individuals, police officers that are in a chase, correct?
Yes.
Okay, what would that be?
Tunnel vision, for example. Psychological components are you tend to narrow your vision to the threat specifically. Sometimes you leave out the peripheral. We train how to overcome that by scanning. We teach officers to continually scan left to right to open the tunnel so that they have a better view and can make a better threat assessment. And there's the adrenaline dump, of course, that comes as well, which, of course, kicks in an awful lot of bodily issues, as well as a little bit of a mind engagement as well. You're attacking the situation in the manner that you can stay safe, keep them contained if at all possible, because you're talking about containment and neutralizing a threat under the circumstances, whether it's cars or foot or whatever it may be.
Don't you want to eliminate the threat?
Well, that word under these circumstances is you want to neutralize the threat. Police officers are...
Is that what you teach?
We teach them to neutralize the threat, to stop the threat, not necessarily eliminate. Eliminate it carries the connotation a little further. You want to neutralize. For example, you may have a severe and ongoing deadly threat that is there. However, you only act with deadly force to a position of neutralizing the threat. In other words, you're attempting to stop the threat. Once the individual is contained, once the individual or individuals can't move any further, once they are surrounded, that's when you keep your cover and give commands, and you're not looking to now eliminate the individuals by any means.
This is what you train the 26,000 police officers you train?
I trained throughout the 50 states, 26,000 officers doing what we call street survival, which is what this is all about.
So this is what you train?
Yes.
Okay. So in this situation with Officer Brelo, when he came, put his car in park, correct?
Yes.
Assessment made by at that point, right?
Yes.
In the assessment, he knows, according to the facts contained in B side, there's all these police cars up here, correct?
Now, according to the facts and what he...
Hold on. Direct exam, not cross.
Sir, did you read the BCI reports?
I did.
Did those facts in the BCI report indicate whether there were cars in this area that I'm pointing to?
And behind his car, 217.
Okay. Would that information somehow be involved in the threat assessments that an objectionable regional officer should make at that point?
Absolutely, because it's a matter of whether it's a continuing threat, such as is the threat going to be able to leave the area, or is the threat contained? That's one of the first things you want to know. Has the threat been stopped to the extent that the threat of going further is no longer existent? The car had been, I don't know whether it really, you would call it ramming, but it was pushed into the 238 vehicle, so it had come to a stop. So at that point, the vehicle's contained, not only because it now is neutralized as a potential weapon itself, but because it has come to a stop. And knowing that there are patrol cars behind and in front, this area is contained, and they are contained. In other words, the movement of these subjects at this point is neutralized. Their movement is neutralized. That's the first component of trying to get control. They had the control of the vehicle.
So, sir, all this goes into training?
It's all training. I mean, a citizen wouldn't know that's what police officers do. Police officers know that because we go through extensive training and scenarios on exactly how to handle circumstances even like this.
Ones that are fluid and dynamic?
That's correct.
Sir, we're starting to talk about Mr. Martinelli's report, correct?
Yes.
Do you know that individual?
I know of him, and he has attended courses that I've taught. I'm not sure we've ever spoken.
There's no report whatsoever. No, and this material is nowhere in his initial report, obviously.
Right. So you got Martinelli's report, and I gather at some point you gave it to Caceres?
Yes.
And did he produce then a report of his essentially criticisms or analysis of Martinelli's?
No, he did not.
Aren't you required to do that?
I don't think I am, Your Honor.
Why not?
Judge, everybody has a different view on these procedures in court. If that's your view, Judge, I'm not going to argue with you. okay, but he reviewed Martinelli's report, and I believe he's allowed to opine on whether he agrees or disagrees with his conclusion.
Didn't you produce supplemental reports of other experts who did review the defendant's experts and give some further opinions?
The only report I know of, rebuttal report, was with the psychologist, Your Honor, Dr. Johnson. We had Dr. Noel review his report. I'd have to check with my trial team, Your Honor, to determine if that was the case.
Your objection, Mr. D'Angelo, is based on?
An opinion not given prior to trial, and the perfect example is what Mr. Gutierrez just stated to the court. We all know as a matter of record that we filed these reports, if my memory serves me correctly, in January. We also received a month and a half ago approximately a rebuttal report from a psychiatrist from New York that the state conferred with after it received Dr. Johnson's report. The psychologist is an expert in our case. So that shows that they know what they're supposed to do. If they want this witness to give an opinion that's outside his initial report based on reviewing other materials, he should prepare a report and give it to us so that we're prepared to respond to whatever his opinions may be. This can't come into court and go beyond the scope of what's in your report. It's true in civil cases. It's also true in criminal cases. The state uses experts many times, and they're aware of the local rules of court and the procedures that this court has imposed on the parties from the very beginning. The audio report as well, they submitted an audio report. We had Mr. Stushman look at it. He did a report. They took that report and sent it to their experts, Your Honor, and we had, I believe it was 5 audio expert reports that were submitted in rebuttal to that. We have nothing from this witness rebutting anything that was opined by Mr. Martinelli, Dr. Martinelli. It is evidently one of the students for the claims.
Didn't say that. Didn't say that at all.
You attended class.
Class, that's right. There's a big difference.
Yeah.
I would also just indicate that when both sides employ experts, I mean, at some point, it has to end. So you have the state's expert says one thing, we produce an expert that gives a report. That, you know, the other side shouldn't get a couple extra bites out of the apple. The court's ultimately going to have to weigh and assess everything it hears and make a determination. This witness has been on the witness stand for almost an hour and a half. The state's had pretty free rein in examining him. We just think at some point it ends and the court has to assess what it hears from both experts. You don't give one another one up, so to speak.
Judge, I'll withdraw the question and reserve the right to call Mr. Caceres on rebuttal if they put on their expert in their case in chief.
And
we're allowed to do that, Your Honor.
We'll object because he's not a proper rebuttal witness.
Well, let's see what happens. But for right now, you say you're not asking about Martinelli.
Unless...
I do think it falls under 16K.
Judge, I believe the court was not going to let him testify about this, Mr. Martinelli.
Yeah, the objection is sustained based on Criminal Rule of Procedure 16K.
Okay. All right. Again, Judge, like I said, we reserve the right to call him back in. And at this point, Judge, I'll finish up my question. Sir, you opine that Mr. Brelo's actions after he was behind the trunk and jumped on behind the car, jumped on the trunk, jumped on the hood, that was unreasonable police officer's actions, correct?
Objection.
Overruled, go ahead.
Yes,
Did you
I said
opine on
everything after being behind the vehicle, all actions after that were objectively unreasonable. That is correct.
And And did Officer Brelo's unreasonable behavior put the occupants of the Malibu at risk of harm then?
Had what?
Did you hear that?
Did what?
Let me ask it again, okay? Did Officer Brelo's unreasonable behavior put the occupants of the Malibu at a risk of harm?
Objection.
Yes.
Why?
Well, because at that time they were contained. There were numerous officers surrounding the area. They were not going to be able to flee, and that means that the threat, by and large, had been neutralized as far as their movement, and now it's an assertion of getting verbal control of them from a position of cover.
Were you trying to tell me that you should have called out verbal commands right here?
Yes. He was very close. I mean, he's within 6 feet.
But he was in the middle of a firefight.
You still give verbal commands.
Even though you're in the middle of a firefight?
Sure.
Well, that seems a little bit odd. Why?
Because you're trying to gain control of the individuals. You have control as far as containment, and they aren't going anywhere. You basically inform them they aren't going to go anywhere. Show us your hands, because in civilian law enforcement, the attempt is to basically stop the threat and neutralize all of the efforts that they may have towards police officers.
But they're shooting at me.
All the more reason why you would stay where you are, keep your cover, and give commands to them to know that they are indeed surrounded, they aren't going anywhere, and that this is over for them. Show us your hands.
So how does that training become involved in all of what you're saying?
How does it become involved?
Yeah, how does it fit the equation here?
Because that is the training for officers who are facing a deadly encounter, is to not expose yourself to being further injured or killed as a result of a containment that has already taken place. Even if there are shots still being fired, the fact that they aren't going to be able to get out but one side of the car, they are covered by other officers if they should attempt to do so. You give them verbal commands that they are indeed contained and that they should show their hands and give up.
But these are split-second decisions, are they not?
Well, they are split-second decisions, but they're decisions that are trained, meaning that you've had a lot of time to think about, if I'm in this position, what do I do? Yes, they're making a split-second decision, but the split-second decision is based on months of training.
Okay. So what you're saying is what Officer Brelo was perceiving at this point in time, behind the trunk, it was objectively unreasonable of him to make a move upwards.
To go upward? Absolutely. To put himself up when there is active engagement or firing going on at that time from the left, from the right, potentially from within the car itself, to put himself in a position of being injured or killed and then causing a risk to all of the other officers that would have to attempt to save his life under those circumstances would be objectively unreasonable, not according to training, and the threat had basically, part of it, a good part of it, had been neutralized. That is, the car had been contained. They weren't going anywhere. In fact, Sergeant Coleman said so at the scene. They're not going anywhere. They're contained.
But a violation of a training procedure doesn't rise to criminal, does it?
I don't make criminal decisions. That's left up to a judge or in this case, judge or jury. I'm looking at what is objectively reasonable by virtue of training of police officers. I'm not trying to invade the province of the judge or a jury if there were one. So whether it's criminal or a violation of procedures or civil is for someone else to determine. I will say that it's violation of procedures. And not whether or not it's criminal. That's out of my jurisdiction.
And that factors into the objectively reasonable standard.
That goes to the standard that officers are judged by, and that judgment comes from the training they're provided and the reasons for that training. They're given the reasons why each decision has to be objective and not subjective. If you decide on your own that you're going to put everybody at risk by jumping up on top of the car and getting injured or killed yourself, causing them to have to now engage in a manner to save your life, you have now deliberately, with subjective decision, put yourself in a position that we train not to be in.
Sir, in all these opinions that you have made are to reasonably professional certainty?
Yes, they are,
And
sir.
are contained in your report?
Yes, they are.
Written?
May we have a moment now?
Sure. Sir, Mr. Brelo's actions, if I were to characterize them as bizarre and negligent, does that comport with your opinion or not?
Yes. Bizarre because it's a series of incongruent actions, as Webster defines bizarre, that do not comport with the circumstances as expected. That's bizarre, and bizarre is not objectively reasonable.
How about negligent?
Not objectively reasonable, or it wouldn't be negligent.
All right, sir, thank you. I have no further questions.
Thank you, Mr. Gutierrez. Do you have any cross-exam, Mr. D'Angelo?
Yes, Your Honor. How long do you want to go before lunch?
We'll probably go to, when did we resume? 11:30, so about 12:30, quarter to 1. So I don't know how long you're here, or how long this cross and any redirect is going to take, but you should be alerted to the possibility that you might have to leave the stand for lunch and then resume afterwards.
Sure, Your Honor. I assume the possibilities.
Okay. So thank you, Mr. D'Angelo.
Thank you, Your Honor. Good afternoon, sir.
Good afternoon.
We're going to cover a number of different areas, but I wanted to go through your report with you. And you have that in front of you, which is State Exhibit 1221, correct?
Page 1, what'd you say, sir?
What's the exhibit number on your report? Exhibit?
I don't have an exhibit number. Mine would...
Okay, it's exhibit number 1221 for the record. I think in your testimony, you acknowledged that you conferred with Mr. Bogdanoff in this case, correct?
Did I concur with him?
You conferred.
Conferred. Oh, I'm sorry.
He brought you into the case, right?
He told me about what he was working on, and he asked if I would write a report. Yes.
So you spoke to Mr. Bogdanoff before you even spoke to a prosecutor, correct?
I spoke with him before I wrote my report.
You spoke to Mr. Bogdanoff before you ever spoke to a prosecutor in this case, correct?
That's correct.
All right. And he wrote a report, correct? You've reviewed his report, have you not?
Yes, I've seen it.
Okay.
Sure.
So I want to ask you if you agree with this principle, and I'm just so you know, reading from his report. Further, numerous courts have considered this issue and held that the violation of police procedures has no relevance on the constitutional question of whether the police have probable cause to believe that a suspect posed a threat of death or great bodily harm to the police at the time the police fired their weapons.
Objection,
Do you
Your Honor.
acknowledge that that's a legitimate principle of law?
Hold on before you answer. The objection is based on what?
He's reading from Bogdanoff's report, Your Honor. He wants to bring Mr. Bogdanoff in. He's going to have to bring Mr. Bogdanoff.
May I interrupt you? May I interrupt you? I'm paraphrasing because I don't have the exact page right in front of me. But in Mr. Katsaris' report, he essentially says, I agree with Bogdanoff, or something like that, to the effect of, Bogdanoff's report is thorough, and I'm not going to repeat what it says in it.
And he adopts it,
So,
Your Honor.
I mean, this is a difference between direct and cross-examination. He can ask him if he agrees that the Earth revolves around the sun.
Not necessarily, Judge. There are constraints in cross-examination. There
Yours-
has to be a good faith-based for it to ask the question. Now, I agree. He can ask if he wants to disagree with Mr. Bogdanoff, but he can't
sit here and read his report. Your Honor.
Hold on. I don't find this objectionable. Your objection is of record, but it is overruled.
Thank you.
So, sir, if you remember the question, you can answer it. If you need to be reminded of what it is, then say so.
I think I've already stated, sir, that I wasn't drawing legal conclusions, which are in the province of the judge to make. And I believe that Mr. Bogdanoff, in this case, with that statement, was stating federal constitutional standards, and I believe we're in state court on a criminal action. As far as what is constitutional and otherwise what may be criminal is out of the arena of my opinion making. I'm here to talk about police training, what they're trained to do, and whether that's objectively reasonable or not. Mr. Bogdanoff made a convoluted statement relating to a series of issues of law and threw in the Constitution on that issue, and I'm opining on police procedures and training.
I mean, you're not serious, are you? You cited the Graham case in your direct testimony.
Objection.
A federal constitutional case, you cited Graham.
Yes, sir.
You were talking and preaching in here today.
Objection.
Now you're backing away from being able to talk about federal law.
You answer here, Judge. He's editorializing.
Well, again, cross-exam is a different beast than direct exam. Certainly, some of this amounts to personality, I guess you might say. But this witness can handle himself. I'm listening to the evidence. People have all different styles on cross. I'm not going to regulate at this point style, which is really what you're asking me to do.
That's not true, Judge. It's not what I'm objecting. So your answer, I take it, is that you're not aware, in all your years of experience, that the law on the proper use of force is a constitutional issue that's determined by the courts. You're not aware of that principle?
Yes, I am, sir.
Okay,
however, the constitutional issues were passed down and incorporated into police training by steps and procedures. And I'm talking about the steps and procedures. I wasn't drawing the constitutional decision as Mr. Bogdanoff did. I drew the police procedures out of the tactics that were used.
Well, we're going to go through your report, and I want you to point out where you're specifying police procedures and regulations. We'll get to that in a minute.
Objection, that's what I'm talking about.
But when you...
That's perfectly permissible on cross-exam.
What, for him to give a speech and not give a question?
Well, he just gave a speech in response to my question, and you won't even let me ask a question.
I don't need, speaking of speeches, a speech in response to the objection. I can figure all this out. So, he basically informed him in his own way. Here's a preview of what I want to be asking you about. Again, I'm not going to regulate matters of style. So, to the next question.
Thank you, Your Honor. Since you have prepared your report in this case, which is dated September 25th, 2013, can I at least get you to acknowledge that that's the date of your report, a direct answer to that question? September 25th, 2013, is that the date you prepared this report?
That's the date that I completed it, yes.
Well, is that the date that's on the face page of your report?
Correct.
Okay. Now, have you been made aware that there was a recent decision by the Ohio Supreme Court in the White case?
No.
Now, you testified in that case at the trial court level, didn't you?
On the what case?
The White case.
Oh, White. I'm sorry. Yes, I'm familiar with the White
Okay.
case.
So
I thought you said Whiteman, and I didn't.
White. Okay. So you were an expert called by the state in that case on rebuttal, correct?
Yes.
And the case went up to the Court of Appeals. It was reversed in part, and then it went to the Ohio Supreme Court. My question is, are you aware of the fact that the Ohio Supreme Court has recently set forth the law on police use of force for the state of Ohio in the White case? Are you familiar with that?
I have not reviewed the subsequent actions taken by the Supreme Court on that case. I knew that it went up on appeal.
Okay. So would you agree that the decision by the Ohio Supreme Court governs the state of Ohio judges on the application of all the principles involved in police officer use of force cases in a
Objection.
criminal
Well,
setting.
hold on. Now, this one is sustained because the witness has just said, I haven't read the decision.
Okay. So you haven't read the decision, and you obviously then don't know what the Supreme Court decided in that case,
I
correct?
have not read the decision.
Okay. So let's take a look at your report, if you can.
Yes.
State Exhibit 1221. And if I may, just to set this in context, you were first called by Mr. Bogdanov on July the 29th, 2013. Do you recall that?
I don't recall the exact date.
And do you recall signing a retainer agreement with the county prosecutor's office?
Yes,
And you signed the agreement and you got a check for $6,000 within a day of that, right?
that's correct.
Okay. So you were engaged in this matter on August the 29th when you received the check, correct?
If that's what the date was, yes.
Of 2013.
Yes,
And then on August the 31st, Mr. Bogdanov sent you a draft of his report. Remember that?
I remember a draft. I don't recall the date.
Okay. And within less than 30 days from that date, you prepared and forwarded your report, correct?
That's correct.
All right. So you were able to go through all these materials, and within a matter of, 3-4 weeks, you formulated your opinion in your 11 1/4 page report, correct?
Correct.
All right. Now, prior to your testimony here today, have you given any testimony in this case previously?
No,
Did you testify at the grand jury?
no,
Prior to your testimony here today, you've conferred with the prosecutor's office, have you not?
I'm not sure what you mean if I conferred with. I mean, we certainly had, there was, yes, some discussion, sure.
Well, what do you mean by some?
Well, as the time progressed, there were some phone calls about the activities that were involved by the prosecutor's office, yes.
Well, from the date of your report, going back to the time that you first were contacted by Mr. Bogdanov on July the 29th, 2013, his billing records only show 2 contacts between he and you, September 6th, 2013, and September 25th, 2013. Does that comport with your recollection?
We didn't talk very much. I don't recall specifically. I know I don't record the phone calls, but
Okay.
we didn't talk very much.
So I'm representing to you from reviewing his billing records, it indicates that he spoke to you for the first time July 29th, 2013, he being Mr. Bogdanov. He then spoke to you again by phone on September the 6th, 2013, and then he again spoke to you on September the 25th, 2013. Would that be consistent with your recollection?
It's not inconsistent. I just don't recall specifically. I didn't archive that information.
Okay. And during that month, let's call it, the 3 to 4 weeks, did you ever confer with any prosecutors, or did you just confer with Mr. Bogdanov?
I believe that there were a conversation or two with Mr. Bell.
During that period of time?
I don't have it. I did not archive the
August to
dates, but
September?
I had some contact with the prosecutor's office. I'm not certain of the dates.
Well, I've read some of your depots, and in your deposition testimonies, you say that you don't take notes, right?
That's correct.
Okay, so do you have any note in your file that you brought up to the witness stand as to when you talked to any prosecutors?
No,
And you don't write, do you?
I don't. What?
You testified in various depositions that you're not one to write publication and articles and things
No,
like that.
I train
You
or
train
teach or instruct. I don't write.
You
That's
train, instruct, and testify, but you
No.
don't write.
That's
Correct? Okay. So, what I'm asking you is, prior to your testimony here today, tell us when you ever physically came down to the Justice Center where we're here today and spoke face-to-face with any prosecutors.
Today,
Today. Did you come here yesterday?
yes.
Okay. Did you meet with any prosecutors in preparation for your testimony here today?
No,
So you didn't meet yesterday with anyone from Mr. McGinney's office or his staff and review what your testimony would be here today?
no,
Did you speak by phone with any of them yesterday?
yes.
Okay, approximately what time did you arrive yesterday?
afternoon. I don't recall exactly the time.
I mean, that's just less than 24 hours ago. You remember if you got here at 1 o'clock, you got here at 5
Close to
or 6
noon. I don't recall exactly
Close
what
to
it
noon?
was. Yes.
Okay. And what time was it? What's your best estimate that you spoke to someone in connection with your testimony here today?
We didn't speak about my testimony. You asked me if I had a phone contact.
Okay.
We had a phone contact. I didn't speak about my testimony. The phone contact came about 3 o'clock.
3 o'clock? Who did you speak to?
Mr. Gutierrez.
Okay. And how long did you talk to him?
3 minutes, maybe at the most.
Other than that 3-minute conversation, when's the next time you spoke with any prosecutor?
This morning.
And what time was that?
7:30.
7:30. So would it be a fair statement that that's the first time that the term active shooter being discussed with you, because it's nowhere in your report? So that came up when you met with them this morning, correct?
I don't know when the first time it was discussed. I have my opinion about the definition of active shooter. I don't recall when it was first mentioned.
Well, was there a question put to you about the concept by any of the prosecutors when you met with them this morning?
I really don't recall, sir. I'm sorry, I don't recall.
You don't recall that? Well, I'll represent to you that it's not in your report. And if you'd like to take a second, feel free to look at your report and point out where the term active shooter is in that report.
I don't know that it is. I was responding to a question today.
Okay, so the first time there was any discussion, you can look at Judge O'Donnell in the eyes and tell him that the first time you discussed the term active shooter was when the question was asked of you in court here today. And that term never was asked of you when you met with the prosecutors this morning.
Your Honor, I don't recall any other conversation. I was responding to a question.
So you're saying that you don't recall. It's not that it may not have been asked.
You know, it could have been mentioned, sir. I don't remember that it was.
It could have been asked maybe, 3 hours ago. You just don't remember, right?
I don't recall that at all. I just said in the realm of possibilities, talking about this file, it may have, but I don't recall it.
Okay. And I'm not suggesting there's anything wrong in meeting with counsel for the state and reviewing your testimony and preparing you for that. I'm just asking you to enlighten us about who, when, and where you spoke. That's all.
And I want to do that and answer
Okay.
your question as honestly
Fine.
as I can. However, in the plethora of materials and circumstances and issues, whether we're talking about the shooter, whether the word active was mentioned, I just don't recall.
Okay. So let's then turn to your report. State Exhibit 1221. The face sheet is entitled Consulting Report, submitted by you with the date September 25th, 2013, correct?
Correct.
And page 1 is an introduction of W. Ken Katsaris, correct?
Yes.
And would it be a fair statement that you set forth some of your background information there, correct?
Some of it, yes.
There's nothing about the shooting or Officer Brelo on page 1, correct?
No, I believe he doesn't come in until
Okay,
number 8.
We'll get to that. Bear with me. Let's turn to page 2. If we go to page 2, would that just be a continuation of your background in this case?
Yes.
Your experience, correct?
Yes.
You go into the experiences you've had at the bottom on page 2 relative to your teaching at legal liability seminars and the like, correct?
Correct.
So there's nothing on page 2 of your report relative to the issues in this case, and no mention of Officer Brelo, correct?
Correct.
Now let's go to page 3. You indicate under report and opinions the legal standard that your opinions are rendered to a reasonable degree of certainty in the area of law enforcement policies, practices, tactics, and procedures, correct?
Yes.
You further indicate that the opinions that you hold are based upon the totality of a very complicated police actions and interactions between a large number of police vehicles and a fleeing suspect vehicle, correct?
Correct.
And then you indicate that your opinion takes into consideration the policies of the Cleveland Police Department and generally recognize police policies, practices, tactics, and procedures, correct?
Correct.
And then you state in the next few sentences there, Graham court terms, right? 20/20 hindsight. You know the case you were talking about,
Sure.
the Graham case. Split-second decisions. You can't use hindsight. You have to look at objectively reasonable and the like, correct?
Correct.
All righty. And then you have an opinion, and you start off with number 1. You talk about Officer John Jordan, correct?
Correct.
And that he had made a traffic stop of Russell and Williams, correct?
Correct.
So on page 3, there's nothing about the use of force at issue in this case, and nothing about Officer Brelo, correct?
Correct.
We turn to page 4. You characterize that Officer Jordan was less than forthcoming in his initial statement, and although there were rule violations, you just mentioned that in passing and then go on to paragraph number 2, correct?
Correct.
All right. And paragraph 2, you begin to talk about the pursuit, correct?
Yes, sir.
You indicate that the pursuit of the suspect vehicle, now known to be driven by Russell with Williams as a passenger, was reasonably initiated after the reasonable belief that someone in the vehicle fired a gun in the vicinity of the Justice Center in the 200 block of St. Clair Avenue, correct?
Correct.
So you're indicating that the pursuit was reasonably initiated based on a reasonable belief that there was a discharge of a gun from that weapon in the vicinity of the Justice Center, correct?
Correct, sir.
And that's your opinion number 2, correct?
Part of it, yes.
Yeah, right. It continues, and we're going to go through it, but I just want to identify for the record the opinion number that we're speaking of, okay?
Sure.
Fair enough? And you indicate that this belief was held by both Officer Vasil Nan and Officer Alan Almeida, who were in the vicinity of Nan's marked patrol car, correct?
Yes, sir.
So that they believed that they were fired at from the occupants of that car, correct?
Correct.
And that there was a loud bang. You have that in your report, correct?
Yes.
And the loud bang was believed by them to be a gun firing, and that it was directed towards them, correct?
Correct.
So from your review of the information in this case, you indicate there, and it was your opinion, that these 2 officers believed that a gun was fired at them by the occupants of this Malibu as it drove by the Justice Center, correct?
Correct, sir.
And you characterized that assessment by Nan and Almeida as being a reasonable perception of those officers, right? In the very next sentence?
Yes.
Because there's corroborative information from other people in the area, correct?
Correct.
So adding to the reasonable perception these officers held that it was a gun firing is the addition of 2 other independent witnesses, a security guard and a parking attendant, who reported it was their belief that a gun had been discharged, correct?
Yes.
So not only did Nan and Almeida believe that the occupants of the vehicle fired a gun at them, there was corroborative testimony from individuals in the area.
Correct.
And in fact, one of those individuals in her statement indicated that she was in a security booth and actually fell and ducked down because of the thought of gunfire.
I believe so. That's correct.
You indicated in your opinion that Officer Nan radioed the vehicle description to dispatch, and you indicated the vehicle was involved in shooting at him, correct?
Yes.
So the opinions that you've given there are that it was a reasonable perception that the occupants of that vehicle had fired a weapon at those 2 officers as it drove by. My question to you is, would it surprise you to discover that prosecutors in this case are questioning whether or not that in fact happened?
That's objection.
This is objectionable, but to my mind only for form. To me, it doesn't matter what would surprise a witness. So, but the substance of the question I don't think is objectionable, which is to, here's what he's driving at. On the one hand, the state concurs with Mr. Katsaris' opinions. Apparently, from what Mr. D'Angelo is driving at, on the other hand, the state doesn't. So the objection is going to be sustained, but for this reason, the locution, would it surprise you, ... I think is almost always objectionable.
Are you, Judge, if I could be that's mischaracterizing the proceedings in this court. For him to sit here and start talking about prosecution theories, which he thinks we're doing, is objectionable, Judge.
So this surprising stuff, the content of that question is completely objectionable. Our theory of the case to you is not what is coming out of his mouth. So he can't sit there and say what we're thinking or what we're saying. Just like Mr. Jangelo came up in opening statement and said that basically you can see that he was on the hood and didn't have a gun. They've been fighting those issues too, the whole trial judge. So he can't sit here and mischaracterize what our theories are or our questions are. This is an expert. We've already indicated that the actions of the officers were reasonable in the pursuit and how it started. So Judge, I object to the content of that question too. It's not proper.
But we disagree with what he said.
Hold on. I already sustained the objection, gave a reason why. I'm not sure I needed either of the two latter comments, but
I'll rephrase
next or a different question.
Yes. Are you aware that the state is challenging the conclusion that you reach that these officers believe that the occupants of that car fired a gun at them?
Objection.
Overruled.
No.
Your opinion continues that Officer Nan radioed the vehicle description, and I think I just said that before, I'm sorry, before I was so rudely interrupted by my friend, Mr. Gutierrez.
Well,
I'll withdraw that.
If
I couldn't resist.
Humor, I appreciate it, but I'm not sure it didn't fall flat.
Okay.
That's okay.
You may have been having eye contact with him that showed that you were trying to let him move. If so, I missed that.
Okay. The last three lines on that page, Mr. Katsaris, with the initial and reasonable perception that the vehicle fired upon the officers, and those are your words, right? The vehicle fired upon the officers, correct?
Yes.
Okay. There was no alternative but to attempt to stop the vehicle. Is that your opinion in this case?
It is.
All right. I mean, that's there in black and white. I wasn't sure if you wanted to change it, but you indicate that there was no alternative but to attempt to stop the vehicle, correct?
By police practices and training.
Well,
that
you
would
don't say that, but you indicate, we'll get to what's in your report.
Objection, Judge. Let him answer.
As a general proposition, you should let a witness finish his reply, even on cross.
Okay. You continue, therefore the initiation of the pursuit was indeed reasonable, correct?
Correct.
You then, in the next sentence, speak about the actions of Officers Seifer and Hummel, and that it was quite appropriate to attempt to stop the vehicle, correct?
Correct.
You then continue on to page 5, but let's go back to page 4 for a second. Would you agree that on page 4 of your 11 and a quarter page report, there's no analysis of the use of deadly force in this case or any mention of Officer Brelo?
Well, erring on the side of caution, I believe we are talking about deadly force because there were shots fired. So I intimated that there was deadly force involved.
Okay, so, but in this case, deadly force by from the occupants of that vehicle directed towards the police officers, right?
Right, but in abundance of caution, I was just saying I didn't exclude the complete content of or context of deadly force.
But clearly, you make no reference to Officer Brelo on page 4 of that report, correct?
I do not.
All right. Opinion number 3 on page 5, you speak about how long the pursuit lasted, 25 minutes, correct?
Yes.
And involved speeds of up to 100 miles an hour, correct?
Yes.
And that there were 62 police vehicles involved in the pursuit, correct?
Yes.
You indicate that many areas of the pursuit policy of the Cleveland Police Department were violated, correct?
Yes.
And you give examples, the paralleling, unmarked patrol car involvement, lack of termination considerations, and supervisory issues, correct?
Correct.
And the entirety of the focus in this case should not be on the pursuit, but rather on the deadly force decisions officers made during the 25-minute pursuit, correct?
For me.
For you.
The agency may wish to look at it, the prosecutor's office may look at it, but I'm saying for my ultimate evaluation,
okay,
that's what I thought.
So continuing on, the next paragraph, and this is still your opinion, correct? Page 5, second paragraph. We're considering, and again, this is under paragraph 3 on page 5, the second paragraph, we're still reading from your opinion set forth in your written report, correct?
Correct.
All right, and it indicates that considering it was reasonable to initiate a pursuit and that the reason was the reasonably perceived deadly force against two police officers, when the initial loud bang was reasonably interpreted as gunfire, this was a vehicle that should be pursued aggressively, correct?
Yes.
And that was your report.
Yes.
And in that sentence, you are categorically stating that it was a reasonable perception by Officers Nan and Almeida that deadly force had been used against them. These are your characterizations, not mine, correct?
Don't be argumentative. I'm agreeing with you.
Oh, well, I appreciate your correcting me, but I just want to make sure that you have no quarrel with the language here.
No, you're doing good.
Okay.
You're getting all
Well, I
agreement.
got to be doing good if I'm reading from
This
your
may
report.
be the most I've agreed with opposing counsel in a long time. I'm
Exactly.
saying that's because you're reading my report.
Yeah, I was trying to give you that softball line.
Thank you.
And again, Officers Nan and Almeida, they reasonably interpreted that as gunfire,
Yes.
and that the vehicle should be pursued aggressively, correct?
Yes.
Okay, now, would it be a fair statement that in that sentence there, you're not challenging Officers Nan and Almeida or making fun of them, are you? You're not doing that, right?
Doing what?
You're not making fun of Officers Nan and Almeida in the conclusions they reached, right? I'm not suggesting you are. I'm just trying to make a point.
Well, that's a bizarre statement that I'm not
Exactly. It is
making fun
bizarre.
of them. Sir, I'm writing a serious report. I mean, obviously, I think I wouldn't be making fun of
course.
anybody
Well,
in any of this.
Right. Well, some people may have, and I just wanted to ask you if you were. Because
Quite
it's not,
incongruent with the subject matter in my
Exactly.
report
Well,
to say that.
Thank you, sir. Your years of experience of testifying are showing. My compliments. So again, you indicate that the vehicle should be pursued aggressively because of the reasonable belief that the occupants presented a real and perceived danger not only to the initial officers that believed they were shot at, but to other officers and the public if they were to escape, correct?
Yes.
So this was a very serious matter. The vehicle should have been pursued aggressively because of the danger to police, other officers, and the public, correct?
That's my opinion.
That's your opinion, okay. And your opinion continues, with this very valid and necessary reason to stop the vehicle, termination was not a reasonable police option, correct?
Correct.
Certainly minor violations and crimes may not require aggressive pursuit, but shooting at police officers is at the top of the dangerous scale in the pursuit continuum that directs pursuit, involvement, and tactics, right?
Correct.
So this was right at the top of the dangerous scale, right?
Correct.
Again, there's another sentence there, but that's the completion on page 5 of your report, of your opinion, correct?
Yes, that's where I take issue with possibly the pursuit matter.
Okay.
Yes.
And there's nothing on page 5 that deals with deadly force other than the deadly force used by the occupants of the Malibu, correct?
Correct.
And there's no mention of Officer Brelo's name there, correct?
That's correct.
Now we get to page 6, opinion 4. You indicate that while it is my opinion that this pursuit violated the Cleveland Police Department pursuit policy, I do not hold the opinion that the suspect vehicle actions and the occupant's specific actions and responses necessitated an aggressive pursuit of the duration and speeds involved, correct?
Correct.
So I'm going to give you another softball here, because on the prior page, you indicate that this was a vehicle that should be pursued aggressively because of the reasonable belief that the occupants presented a real and perceived danger. But on the very next page, you're saying that it necessitated, you do not hold the opinion that the suspect vehicle actions and the occupants' specific actions and responses necessitated an aggressive pursuit of the duration and speeds involved. Could you please explain the...
Sure.
The two.
I was talking about two different situations. One is that an aggressive pursuit needed to take place. Now I'm defining that according to the Cleveland Police Department policy, the aggressive pursuit which they allow for in the policy, was violated. So while an aggressive pursuit is certainly, I think, required, I go on to talk about the fact that this particular pursuit went further than it needed to. For example, 62 vehicles where the department says 2 and supervisory can add more. That doesn't mean that it's not an aggressive pursuit. However, I think that they took aggressive off the chart when they went with 62 vehicles. So I was kind of delineating that, yes, an aggressive pursuit is necessary, but you can aggressively pursue within policy.
Okay.
And I think I was making that distinction.
That was your point. I just wanted you to clarify it for me.
That's my opinion.
So the fact that the pursuit policy would allow for more than 2 based on judgments made by supervisors, I take it you're saying that no matter what their judgment may have been in that respect, that 62 would have been way too many.
Yes.
Okay. But nonetheless, the Cleveland Police Department should have continued to aggressively pursue that vehicle.
I agreed with that, but I think that the policy should have been, and that's where the next sentence comes in, should have been controlled by supervisory guidance.
I understand.
And that's where I'm going with it. I'm starting with the general, and now I'm bringing it down to the more specific, and I'm making the opinion about the pursuit a little bit more definitive. Not that it wasn't and shouldn't have been aggressive, it's just that it should have been aggressive within policy, because the policy is directed at safety for the citizens and the officers alike.
Okay? And in fact, you indicated in the middle of paragraph 4, I fault the lack of supervision for the pursuit issues that appeared on the streets of Cleveland more than the specifically focused individual officers attempting to stop a deadly threat, correct?
Correct.
So you're saying that it was the supervisor's fault, and in fact there were supervisors actively involved in this pursuit, correct?
There were a number of supervisors,
Okay.
sergeant to captain. That's correct.
But your language is that you still characterize the individual officers were attempting to stop a deadly threat. Who or what was the deadly threat?
They were shooting.
But who or what? Who's they?
The subjects in the vehicle they were pursuing.
Okay, the subjects in this Malibu, right?
Yes.
That threat, your opinion goes, reasonably continued to present as a deadly threat by not only the high speeds of attempt at escape, but by reasonably articulated and specific actions of the driver and passenger overlaying the fleeing that gave the officers every reason to believe that at every turn this vehicle and its occupants were preparing for, planning, and attempting to impose deadly force against the officers. That was your opinion?
That is my opinion.
Okay.
That's right.
So those occupants, according to your analysis, were preparing for, planning, and attempting to impose deadly force against the officers, right?
No. It's my opinion that the officers mistakenly, but still could perceive and believe that. I didn't say that, but that's my opinion. In other words, given what the officers were faced with, I do not fault the officers for thinking that.
Well, we're now talking, though, and I know you want to add more to what's here, but I'm trying to take you through what's in your report in black and white. If the prosecutor wants to ask you other questions about what else you want to add, that's fine. But I'd just like to cover your opinion that you provided in a written document.
I'm explaining my opinion.
Okay. So you would agree that there's nothing in that sentence that we just reviewed that in any way talked about a mistaken belief, correct?
I did not say that because at the time the officers did not know that. So I was using what the officers knew. That's correct.
And when you wrote this report, you did it in the comfort of your home or office, correct?
I was not going 100 miles an hour in a pursuit vehicle.
That's
no.
right. And
I was at home. You're right.
And you weren't dodging crossfire or bullets coming.
Neither was your expert.
Right.
That's right. That's how it works.
Right. And there were
you probably know that already before you ask the question.
There were no sirens going on and no emergency flashing lights, right?
It's a good tactic. I have time to think about it, and they didn't. I understand, sir.
Okay. So before we get to your opinion number 5, you would agree, would you not, that other than the deadly force that's referenced in paragraph, your opinion number 4, the deadly force used by the occupants of that vehicle towards the police, there's no discussion on page 6 about the deadly force used by the Cleveland police officers and Officer Brelo.
Correct.
Okay.
Let me interrupt you, Mr. D'Angelo. We're about to start on paragraph 5, and Amanda, you've been going, but we'll take a break at this point. So, sir, you remain under oath, and we'll resume at 5 minutes after 2, but you're certainly welcome to step down until then.
Thank you, Your Honor.
See you then. We'll start at 2:05. We're off the record. Thank you, lady and gentlemen.
We have not passed, sir.
Yeah, Pat D'Angelo, nice to meet you.
Good to see you, sir. My pleasure.
Don't, you know, obviously, I'm